This year, I am Dorothy Hairston Mitchell. I have been on the council, I believe, since 2017, and I have loved every moment of it. I serve now. I have been serving on the ethics committee for, I think I'm back on 2 years now. Since I've been a judge. I can't remember, it's 2, maybe, I don't know. But I left, I was here first, and then went to grievance and I'm back here, and I'm super excited. And I know those of you who were at the orientation, Brian spoke about you not needing to be an expert in ethics, but you absolutely have the opportunity to become one when you're on this committee. I think you will appreciate this work that we do here. It's really good work, and he is absolutely correct that you will be looked at as if you are an expert in ethics when folks find out that you are on this committee. So soak it all up as much as you possibly can. So what I want to do first is we will start off with introductions. And as I said, I'm Dorothy Hairston Mitchell. I get to serve as your chair this year, and I'm super honored to be able to do that. And I'll pass it off to everyone else. Who's our vice chair?
Good morning, everyone. Davis Poisson. I'm the vice chair. This is my 4th year on the council. I've been on ethics all 4 years. Really enjoy it. I think that it's a great learning experience and a great way to get to some good conversation.
Bill Powers from Charlotte, North Carolina, advisory member. This is my 3rd time being on it, and I've really enjoyed it. I like the theoretical aspect of what we do, and the people really been fun to work with.
And I'm Evan Rawls. I'm a counselor from Mecklenburg County. Been on ethics for the last 8 years. This is my 9th year, last year, and have really loved the work here. Loved working with people. It's been, and Brian, just all been awesome to work with. And so have the committee members. The subcommittee members do great work. And so I'll miss you guys, but this is my last year. And Warren's too. Oh, Warren's crying.
Good morning, Eddie Thomas Jr. From Mecklenburg County, advisory member. This is my first meeting. I'm forward to being part of this group.
Hey everybody, my name's Anna Hamrick. I'm a counselor from Asheville. This is my 9th year on the council, so my last year too. My first year on ethics. I've done 8 years on grievance. I said, can I do ethics for my last year? Because I've never done it. I wanted to see what it was like, so I'm excited to be here.
Great. I'm Warren Savage. I'm a counselor from Wake County. It's my 9th year, and my 11th year, I think, on the ethics committee because I was an advisory member before that. So it was a great place to be.
I'm Wayne Michael from Lexington. My district is Davidson and Davie counties. I'm a new counselor. This is my first meeting.
I'm Cindy Badger from Wake County, and I'm an advisory member on this committee, and I get to run my second
Kevin Kiernan, Sampson, Duplin, Jones, and Onslow counties. 5th year bar counselor, 5th year on ethics.
I'm Liz Harrell from Wake County. It's my 3rd year as an advisory member on ethics.
I'm Tara Ward from Columbus County, also practice in Rosen, Brunswick, and Robinson counties. This is my 3rd year as advisory member on ethics.
Good morning. My name is Fran Muse. I'm from Orange and Chatham counties. This is my 3rd year as an advisory member. I was going to ask Brian to send me his PowerPoint slide on how an ethics rule is made, because I think I might actually understand it now.
Yes.
I'm John Leidy. I'm a counselor from the 1st Judicial District, which is Adair County through Chowan and North Gates County. This is my 2nd year on the ethics committee, and I agree with Brian. I think I understand it.
Hi, I'm Lori Vitale. I'm an advisory member. This is my 2nd year on this committee, and I've really enjoyed it, and I mirror your comments that I kind of get it now.
I'm Nancy Grace. I'm a family lawyer here in Raleigh with Wake Family Law Group. I'm a counselor for the 10th, and this is my 2nd year, so 1st term, 3-year term as a counselor, 2nd year as a counselor here, and 2nd year on the ethics committee.
We're sophomores.
We're sophomores, that's right.
I'm Wade Harrison. I'm from the 17th Judicial District, which is Alamance County. And this is my 2nd year on this committee, and I wish I could say I understood it.
I'm Jay Vanoy. I'm from Wilkes County. I cover Wilkes, Yadkin, Ashland, Allegheny counties. This is my second year as a counselor. I served on this committee 2 years as advisory member too, so I'm still learning.
I'm Bill Rogers. I'm a counselor from 25th District, which is Cabarrus County. I practice in Concord, family law. I'm in the same class as Wade and Nancy. It's my second year on the council, second year on the ethics committee. Enjoying it, still trying to figure it out myself.
Good morning, Christy Pearsall, Guilford County, and I'm an advisory member, and I can't remember how many years I've been on, at least 3 now.
I'm George Cleveland. I'm a counselor from 31st, which is Forsyth. I'm a district court judge there. I was in private practice for 30 years. I've been on the council. I believe this is going to be the last year of my second term. And haven't been on this committee long. I was on grievance for years, but then when I got on the bench, they kicked me off grievance. Nice to be here.
I'm Martin Scott. I'm here at Terrace area. We're down in southeast North Carolina, and it's my second year on the on the ethics advisory position.
I'm David Allen, litigated in Charlotte whenever I get a chance. And if Nancy and Wade were sophomores, I'm a grad student. I've been on ethics for a long time. I took a couple of years off to go visit with the folks on grievance, and I'm very happy to be back on that. I didn't enjoy my time on grievance.
I'm Craig Lynch. I practice commercial dirt in Charlotte, and this is only my second year on this committee and also on the council. And if anybody knows where the teacher's manual is for this,
I'm Patty Hedge, formerly of Wake County, lived here for 43 years and then moved to Lake Gaston, Littleton, North Carolina, if you know where that is. And this is my 4th year as a counselor, and I've been on grievance before and wanted to try ethics. And I represent the people of North Carolina because I'm a public person on the council.
Lamar Armstrong from Johnston County. I'm an advisory member of ethics, and I've lost count. Maybe this is my 8th year, something like that.
Good morning. I'm Jeff Foster. I'm a new counselor from 3rd District in Greenville. I'm a Superior Court judge. Excited to get a chance to work with all of y'all on this committee.
Tom Langen. I'm a District Court judge in Surrey and Stokes Counties. My 3rd year on the council, 3rd year on ethics.
Takia Lewis Blaylock from Ahoskie, represent Hertford, Berkeley, Northampton, Halifax County. I have a general practice, and I believe this is my 5th year on ethics and on the council in general.
I'm Julie Bell. I'm a district court judge here in Wake County. I'm a bar counselor, and I'm not sure, I think this is my 4th or 5th year on the council. My first year I was on grievance, and then when I became a judge, so probably 4th, had moved to ethics.
I'm Suzanne Lieber. I've been assistant ethics counsel with the bar for, I think, 17 years. It's nice to meet everybody.
I'm Nicole McLaughlin. I am one of the other assistant ethics counsel, and I'm in my 20th year at the State Bar come June.
And we are all the better for it. I'm Brian Oden. I'm your ethics counsel. I've been with the bar since 2007.
All righty. Thank you, everyone, for those introductions.
Can we quickly point out the most important person that you're going to interact with during your service on the ethics committee? Lanice. I know Lanice is going to just yell at me endlessly when we get out of this meeting.
I do it so much more subtle than you.
I'm assistant to the ethics committee. I assist Brian. Unfortunately, he has the pleasure of working with me all the time. Alice and Peter, and I am with the specialization program as well. And I love working with ethics. It's one of my favorites. And all the people are great, and it's good to hear some of the discussions that we have with here.
And she gives the best hugs. By the way. All right. Thank you again, everyone. And with all of that being said, we will get started with our agenda. And I will first read our members of the committee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and are instructed to refrain from participating in any matter coming before this committee with respect to which there is a conflict of interest. So if you have a conflict of interest that you know of right now, please let us know, or when we get to an item, if you realize at that point that you have one, let us know at that point. And we will move to our special agenda items. I think we're starting administrative matters with Ann. Yes, good morning.
You want to introduce yourself real quick, too? I knew
Yes.
you were about to come up.
Most of you know, I'm Ann Parkin, the field auditor with the State Bar. I'm in my 11th year in this position. I was in membership 95 to 2005 for 10 years there. So most of the new members will see me for an audit sometime during this year. The others have seen me for an audit before. So the audits for the fourth quarter were conducted in judicial districts 3 and 10. District 3 was last audited in 2017. District 10 was last audited in 2019. 2 audits were conducted in District 3. 38 audits were conducted in District 10. The 2 most common rule violations were that 45% failed to review bank statements and canceled checks each month, and 40% failed to complete quarterly transaction reviews. And based on the new random selection and the geographic plan for 2024, audits for the next quarter will be conducted in Durham, Guilford, Mecklenburg, Orange, and Wake counties. Any questions? All right, have a good meeting.
And I just want to let everyone know, if you weren't on the Issues Committee yesterday, you wouldn't have heard this, but the random audit process, historically has gone through and selected counties or districts at random. But of course, over the years, we've seen a concentration of lawyers in particular counties. I think Wake and Mecklenburg counties make up something like 47% of the lawyers in this state. So we had a study last year that essentially concluded the random audit process needs to be adjusted. And essentially the entire state is now the group from which lawyers are selected. And as maybe you can see in the fact that the first quarter audits will be conducted with lawyers from Durham, Guilford, Mecklenburg, Orange, and Wake, the most populous lawyer counties. So it's the idea to not concentrate audits on particular districts where there aren't any, or there aren't many lawyers. Those lawyers were complaining, saying, every time my district comes up, I get audited. Whereas if I'm in Wake County, I might get audited once in my career, maybe. And so just to make it more equitable, then we're just taking a random selection from the entire state now. So just want you all to know that, especially if you run into anybody that says, what's going on with this random audit process? I feel like more people in Wake and Mecklenburg are getting selected. Well, that's why. So just want you all to have that information.
And reviewing the results, I don't know whether the percentages are good or bad, or what our targets are. I don't know if there's anything that you could provide us to serve as a poll star to evaluate that, but from my perspective, they seem high.
Yeah. What's your experience been, just historically? I mean, you've seen the same numbers typically quarter to quarter?
For the larger districts, yes, because when we just selected the 2 districts, they were apportioned on the size of the districts. So whenever Wake and Mecklenburg were selected as districts, I did do more of the audits there because that's where the highest population is. But for the new selection, when we based everything on the whole statewide attorney population, the results were that Wake and Mecklenburg are going to get the bulk of the audits for the year. This is based on 200 audits being conducted each year. And so with the smaller districts, I'd say 45% of them, I'll be doing like 1 audit in a county. So we're not doing it by district now. So it could be that the districts that have quite a few counties, I may be doing 2 or 3 audits. But that's for the whole year. And so the results from the randomization, I think, were very positive and proved out that the selection based on population is gonna be beneficial to the smaller, not beneficial,
How about rule violations, like the common rule violations? I feel like those numbers are pretty consistent.
Yes.
And we don't have a particular benchmark. I don't think of, we want lawyers to get to this percentage, but I feel like you've been doing the random audit process for a decade now?
Yes.
At least, and they seem pretty consistent at that level that you see in the report.
And I will say, I think there's some theory that smaller law firms or solo law firms are more apt to have a violation or a deficiency. But I was in Wake County and you saw where I did all but 2 of my audits for the quarter. And I audited some very large firms and those statistics didn't change for the violation. So it's more knowledge than it is anything.
Thank you so much for that report. So next we'll move to report on ethics phone calls during the volunteers.
So you were here for the introduction. You heard Brian talk about the ethics hotline, and not everybody knows about it, but a lot of people know about it. In the past quarter, we answered 1,049 ethics inquiries, and that is above average for what we've done in that particular quarter. I like to give you ideas of what the most often, what questions we get the most often. So the top 4 for the past quarter: conflicts, always number 1; advertising, number 2; confidentiality, which you're going to see us discuss later today; and firm dissolution, which is something that we often have ethics questions and ethics opinions on.
Any questions? All right, thank you. Next, report on CLE ethics presentations.
All right, you'll see in your materials that we did a collective 4 presentations over the past quarter, which is down from the, I think, 15 or something we did the prior quarter. And I'm sure this next quarter is going to be high because it's the end of the CLE year. We're already getting requests. But we do want everyone to remember that the ethics staff is available. We'll try to make it work with our calendars. But if it works, we want to be able to get out there and meet with your different organizations, your districts, and not just spread the good word about ethical lawyering, but maybe put a face with the name or just a face associated with this thing that they understand to exist called the State Bar. So please do keep that in mind if you have a CLE need.
All right, and now we move to the meat of our member work subcommittee reports. First, inquiry of Brady. The agreement requiring payment of estate planning lawyers' future legal fees.
That's me. I hope everybody can hear me. I usually have a microphone. So this inquiry has been around for a few quarters, and it is still in the subcommittee, and it's going to probably remain in the subcommittee because we were not able to meet the last quarter. The issue is whether a particular fee provision is prohibited by the rules of professional conduct. The original inquiry arose in the context of estate planning law firms. Often estate planning lawyers are required to participate in proceedings related to estate planning documents after their client's death. Because there is no longer a firm client, the lawyer's time is not billable. And estate planning firms would like to include a provision in their fee agreements that would help them to recoup some of the fees and expenses that they've been incurring. A proposed fee provision was included with the original inquiry, and this fee provision originated from the American College of Trust and Estate Counsel. The copy of the full provision is in your materials, but basically the provision requires the client's estate to reimburse the law firm if a lawyer is deposed, called to testify, or required to respond to discovery concerning any aspect of the client's estate plan, and the lawyer's time would be billed at the lawyer's future hourly rate. A proposed ethics opinion was presented at the April 2023 meeting, and the proposed opinion concluded that this provision did not comply with Rule 1.5, which is the rule of professional conduct that pertains to fees, because it's vague, overbroad, and could lead to a clearly excessive fee. Some members of the committee at that meeting felt strongly that some variation of this provision should be allowed for estate planning lawyers in particular, because these types of fees and expenses are foreseeable in that practice area. The inquiry was sent to a subcommittee for further study, and we are continuing to study that inquiry.
All right, thank you very much. Does anybody that serves on that subcommittee, would you like to speak? Yes, sir.
It's gonna be a difficult issue. I'm gonna have a hard time getting to yes on this, but I've talked to the state planning lawyers in my district who have convinced me that this is a big problem. And they can't, bill on the front end because nobody's going to come to you to prepare a will for $15,000 and you're gonna wind up in grievance with a complaint for excessive fee. But nevertheless, it's a problem, and they understand why it's a problem. And my concern about it is carving this very narrow exception to a rule just to satisfy a particular practice area, but it goes beyond that. The client is dead. He's no longer directing the attorney's efforts. Moreover, we have to assume, we're assuming that every caveat is in bad faith, when in fact, the caveat is saying, no, it's not what the testator intended at all. I mean, that's usually the purpose of a caveat. So you're tying up money that is no longer, it's now part of an estate, which means it's somebody else's money. And if you're gonna bill at that lawyer's hourly rate, first of all, he's offering witness testimony, not professional services, professional testimony. And he may no longer be an attorney. He may be a judge. He may be retired. He may have moved and practice in another area or do something different. And it could be 30 years, theoretically, or more, from the time that the documents were prepared. The other issue is if it's a claim against the estate and you bill as an hourly rate as a witness, well, you're going to be so far down the chain, you're probably never going to see money anyway. So I understand it's difficult. I sort of wanted to take the default position that we do nothing and lawyers just be on guard, not to charge excessive fees. I have a lot of problems with this, but I do understand people who practice in this area. When you're attacking, if there's a caveat, you're attacking the lawyer's competence, perhaps his ethics. It's all hands on deck when this happens, and it can really affect the law firm's business. So I am sensitive to that, and we're just going to have to keep on working on this, and maybe we can find something.
Thank you for that.
Tom, I have a question. Future fees, are they collected up front and held in trust? How do you manage future fees, especially when the client is dead? And holding fees in trust for decades is problematic by itself.
They're not collected in advance.
They're not, okay.
These are fees and expenses that would be incurred at the time of the collateral proceeding.
Unless you pay them. Unless you bill on the front end, but nobody's.
You can't, I mean, there's no way to know how much.
You can't. Thanks.
Any other yes, sir.
This has been discussed a few times, and I sort of struggle with the concept of billing for services as a witness when you're in fact a fact witness. I've had, I think, 4 caveats where I subpoenaed the drafting attorney. In each of those cases, the drafting attorney came and provided evidence and testimony as a fact witness. And never once have they submitted a bill for that. And so my issue with this is it a legal service, or are you simply providing information as a fact witness? I think that's really what it is.
We have, I think, at least one other subcommittee member. Do you have anything you want to share?
We're reaching out to the estate planning board to get more feedback about it. But, this is a problem.
All right, we have some great members on the subcommittee, so y'all keep working at it. All right, yes, I was gonna see, is there anybody else, full committee, anybody else want to be heard on this? All right, I'll entertain a motion.
So moved.
All right, to return to subcommittee. All right, Do I have a second?
Second.
All right, I have a motion and a second to return to subcommittee. Any discussion? All right, all those in favor, please say aye.
Aye.
Any opposed? All right, goes back to subcommittee. Thank you, everybody. Next, we have use of artificial intelligence in a law practice.
All right, that's me. So this, I mean, that's my digital self. So this inquiry was introduced last year, and in light of all the different talk about artificial intelligence and the leaps that the technology has seen just in the past 12 months. The question that was presented is essentially, what is a lawyer supposed to do? How is a lawyer allowed to incorporate artificial intelligence into his or her practice? The inquiry really comes from a variety of places. We've received on the staff, we've received questions from folks just requesting information of just what the heck are we talking about when it comes to artificial intelligence, to specific questions of can I use this particular product? And generally speaking, we wanted to open this inquiry, start a subcommittee to look at these different things, and the first conclusion was that we're going to shoot for an opinion that addresses the broad issue of if a lawyer is allowed to use artificial intelligence in a practice. We typically, in our opinions, do not address specific applications because those can change very quickly. The opinion becomes outdated really almost by the time it's published. And so the subcommittee concluded originally that it would be appropriate to pursue an opinion that addresses that broad issue of can a lawyer use artificial intelligence in a law practice. The subcommittee met twice over this past quarter, and there is a proposed opinion in the supplemental agenda. The general opinion, or the structure of the opinion and the answers that the opinion provides is that yes, a lawyer can use artificial intelligence. In fact, the opinion tries to provide some background information on artificial intelligence and just, I guess I feel like it's an oversimplified attempt to just provide the reader with a little bit of education on what is artificial intelligence, and frankly, that lawyers have probably been using artificial intelligence in a way that they didn't even realize was artificial intelligence for some time. I think, stuff like Westlaw and Lexis is a great example. But after that background, just answering the simple question of can a lawyer use artificial intelligence in practice, the answer is yes. But if you're going to use artificial intelligence, just like any other software, any other tool or resource, a lawyer needs to do so competently. He needs to ensure that confidentiality remains protected. And essentially that the lawyer is responsible for the work product of that artificial intelligence. And I think the example of that that we probably have seen in the headlines from last year in New York, there was a lawyer that essentially used artificial intelligence to draft a brief and looked at it very, very casually, said it looks good, and turned it in as his brief. Lo and behold, I guess he used ChatGPT to draft the brief, and the program hallucinated quotes and cases and citations and all that kind of stuff. So, the lawyer is ultimately responsible for that. And, so the answer just being generally yes, you can, but you need to be responsible, just like anything else. The other inquiries addressed questions like, can a lawyer use a third party's software program? There are a lot of third-party programs, Thomson Reuters, Lexis, they're all coming out with their own AI drafting assistants, or maybe there's some other AI process to evaluate or kind of run through a variety of information classifications. Maybe it's a discovery thing, maybe you're evaluating title, whatever it might be. And so the question being, can you use a third party's AI software? Well, yes, but just like you might use a third party's cloud storage, you need to do the homework to see, is this something that I can trust? I have a duty as a lawyer of confidentiality, so if I provide information to this third party, is it going to remain confidential? What security measures do they have in place? And so that second opinion tries to articulate just what a lawyer's responsibility is and the parameters, and even give some ideas as to some of the questions they need to ask. It also refers back to some prior opinions. We had an opinion from 2011 on software as a service. where lawyers are using third-party software, and so there's some considerations that the lawyer has to give. Looking at the experience and the reputation of the provider, looking at the terms of service. How is the information that you provide to this particular program or this particular company going to be used? Is it retained? Is there ownership rights? Anything like that? And that's particularly important with artificial intelligence because a lot of these different, I guess maybe the newer forms of artificial intelligence that are grabbing the headlines are these generative artificial intelligence processes where they create work product, they create a brief, they create answers based upon information that it retains, that it has been trained on. And so one of the questions when you put client-specific information into these programs is, does that information get sent back to the program to train on, and therefore could it be potentially used as it creates for, say, I don't know, another person. That other person might be the opposing party. Things of that nature. Just looking, but it's, again, the opinion tries to encourage lawyers, you got to look at the terms of service, and how are the different safeguards set up here. The third inquiry goes into this question of, law firms that are currently looking at third-party developers to develop an artificial intelligence program in-house. Can you do that? Again, yes, you can, but you need to make sure you know what's happening. Because some of these third-party developers, again, because they have artificial intelligence, generative artificial intelligence, they might be sending information back to their hub for continual training. Be aware of how the information is being used. Again, I think that's the theme that you see throughout this opinion. There's no kind of strict prohibition, do not use artificial intelligence. It's kind of a be cautious. If you're going to use it, you better know what's happening. And if you don't know, if you don't feel confident in what it's doing and how safe the information, the client-specific information you are putting into that particular program, then you probably need to think twice or at least educate yourself more and continually educate yourself at that on this topic. The opinion also goes into a question about billing, and we wanted to include that just to make sure that that there's some clarity on what exactly is a lawyer allowed to bill, because realistically some AI processes will cut down the tasks that previously took an hour to maybe 10 minutes. A lawyer needs to be accurate in their billing, and then of course the opinion also addresses just how you might attribute the expense incurred in having AI work for a particular client. When can you attribute that expense to the client versus when it's just more of a general expense, similar to how you might be paying to have access to the internet for your office, things of that nature. So again, the opinion it went through a couple different drafts. The subcommittee discussed it to a great deal, and it's in your materials there for your consideration. So with that background, I guess Warren, as our chair, and the king of artificial intelligence, can take over.
We had a dream team, ethical legal minds on this, I will say, if you look at our committee and subcommittee. Definitely, I think we have hashed it out. We danced on the head of a pin at the last meeting, but we've hashed it out quite well. I think we've got it right. What this opinion allows us to do is it's the first of what I feel will be many AI-centered inquiries and opinions through years upcoming as we get used to how lawyers actually use this stuff. And it gives us a good base on which to build and be more specific on future inquiries. I think it stands in stark contrast to old ethics opinions that we had back on previous cataclysmic technological things that were upcoming. I pointed out to Brian back in 1999 we issued an opinion based on the upcoming Y2K problem. Everybody had asked, what are the ethical duties that lawyers have to make sure that their trusted funds are held in a bank that will protect them when Y2K hits. And the ethics opinion, and I'm not kidding, said a lawyer must use reasonable care in selecting a financial institution to hold your trusted funds, period. That was it. I thought that was very awesome. awesome.
That was version 1 of the proposed opinion, but we expanded.
So anyway, I think I'll let the other subcommittee members speak. We got a bunch of them, and all thought had very insightful things to say to reach this point. But I think we're all of the opinion that we would like to have this approved today by the council tomorrow to be published for opinion. Correct? For comment.
Any other subcommittee members want to be heard?
Yeah, I'll add that, as Brian said, part of the opinion is educational in some aspects. And we talked about, and I think it's there, that this idea that there's what we call it, editors.
Yeah, editor's note.
Editor's note that when there are other resources available that we can add to the opinion later that further educates lawyers on what exactly artificial intelligence is and how it applies to a law practice, that we, from time to time, the editor can add those links, add those resources without having to come back every time AI changes, which is like every day, to add more informational sources. So I think that will be helpful as we move forward.
Two things, I'll underscore the confidentiality comments that Brian shared. I think that's really something that is vitally important to understand and to make sure that you're complying with your obligations under the rules with respect to client confidences. It's really handled in greater detail in written work product, so I recommend that to you. But the other thing is, as you and people you know start to incorporate the use of AI in your practice, to the extent that you identify issues or things that ought to be addressed by our subcommittee, please share those, because this is iterative. This is something that's going to morph, and as Warren said, and as I told Brian, this is going to be part of Brian's life for the foreseeable future. And from my own experience, I think lawyers who are in trial practice or litigators are probably going to take advantage of this more readily than people in the transactional world, where drafting specific documents is something that's nuanced. But again, that's just an observation, but I bet you that my good friend David Allen will probably be immersed in AI.
Absolutely not. Intelligence, much less.
Anyway, be free with sharing experiences with us, because I think that'll be helpful.
Absolutely. Any other subcommittee members?
Just briefly, I've just been Brian did such a great job of breaking it down, this big behemoth of the issues. When I got assigned to this subcommittee, I mean, you think of the main issues, the guy in New York, nobody wants to present false information, but when you think about confidentiality, when you think about if clients instruct you, I don't want you to use AI, I want it to come with these other secondary issues that come up. I feel like this opinion does a good job of distilling what most lawyers are going to ask about this huge issue. There's always going to be 10,000 other questions every week, but I think everybody did a great job of boiling down what are the most pressing issues that we have right now, and what are the most common problems that are going to arise. And I really appreciate that you were able to pull that down.
Yes, ma'am.
I'm Lori Vitale, and I was on this committee. I asked to be on this committee because I didn't have a true understanding of what the term AI encompassed. And so we really did spend a good bit of time trying to define that. And Brian, I think you did an excellent job. And that's part of the reason we kept the door open, is as it evolves, he has the opportunity, if he chooses to add more articles and define it further. And I think that's great because it is ever evolving. And I think the younger people that are in law school now, they're learning about this in their ethics classes. They're using it. For those of us that have been practicing a long time, or I'll just speak to myself, I'm uncomfortable with technology. That's why I asked to be on this, because I try to force myself to learn it, but I think the younger generation is just the opposite. So we need to know as younger lawyers come into our firms and as we're interacting with them, we need to know where they sit with this because they're much more comfortable with it. And as the elder lawyers and mentors, we need to know how we guide them in this process. And also, an important thing that I think we really talked about more in our last meeting than prior meetings is at what point do you inform the client? I mean, if you're using Lexis or to do your research, it's one thing, but if you get to a point where you're using ChatGPT, you're plugging in their personal information, first of all, you need to ask, can I keep their information confidential? But second is that, have you reached a point where if you're putting in personal information about them into an AI program, do you have to inform them and do you need to get their consent? And so I think that the opinion leaves that in large part to the lawyer's judgment, taking into consideration a lot of the rules, because there will be such a broad spectrum of times when AI is used, but it's certainly something we need to think about. And think about, and this isn't addressed in the opinion, whether or not and how to potentially put it into a contract if you know you're going to use it, or if these younger lawyers tend to use it. Think about that. Get their consent, have a conversation with them about it. And so I think the fact that the rule even raises discussions with the client about that is really important. So, thank you.
Yes, ma'am.
I know we can't be prescriptive with regards to billing, but it is very broad, and I think that you guys should probably just get ready for the lovely fee dispute staff to have some issues with that, because if it does take 10 minutes, right, then do you only bill it wasn't even your time, but like, do you only bill 10 minutes? Or do you say, oh, right, I can bill 2 hours instead of whatever than 5? So I think the opinion's great. I just think that there's gonna be a lot of controversy, I would assume, with the billing aspect. And some additional guidance at some point, I think would be helpful, especially to Lori's point with younger attorneys coming through feeling really comfortable about it. I think we're getting into the process of some attorneys, I don't use it, I don't feel comfortable using it for my purposes. And I think because we're practicing family law, our issues are so specific and it's so fact specific that I just wouldn't use it. But I do think that there will be attorneys that do. And I can only imagine that there will be a number of clients that feel like if some other computer system produce something in 3 minutes, because they do it so quickly, right? And ChatGPT can do something in 30 seconds. Then what is the actual work product that the attorney can actually go for when we didn't do anything? So do you just go through the review time, right? So I don't know if you guys got into that more specifically. I just am concerned about the fact that this is going to be problematic for a number of
And I think that issue will come up regardless of this opinion.
It's gonna bring up the question of flat fees versus hourly billing. But I know if I just charge a flat fee for a particular task and I use AI, previously took me an hour, or I'm taking the risk that it's only gonna take me an hour to draft something. Now it only took me 15 minutes because I got a head start with ChatGPT, then there is gonna be that question, is that clearly excessive to charge the exact same amount that you previously charged? That's something that I think I feel like we all kind of see it on the horizon. And frankly, I think we need to see how it plays out, because I think jumping to a conclusion right now might be a bit premature. But I think you're absolutely right, Sydney. It's gonna be a problem.
Yes.
I'm not on that committee, but I think what you've done here is created a very sound and organic foundation for this to play out in the future. And you've grounded it in fundamental principles that have been around for years. And you've focused the responsibility on the individual attorney, which is where it has to belong, because we can't even imagine the questions at this point. So I think I'm proud of what you've done.
I will tell you all in regards to the law students and younger lawyers, two things. One, the law schools are definitely teaching on this, not only in the ethics classes. I know for sure in North Carolina Central School of Law, they have an entirely separate class specifically about artificial intelligence and use of it. And I know other law schools are doing probably the same. Also, I heard a law student told me this past summer that a law firm she was working at, she got a tongue lashing for not using AI and actually utilizing that because they knew and thought that her time would be less, she would spend less time using AI, and that she took much longer and could have just used the programs. And so I think we are getting it. We are definitely going to get it from all ends. I'm glad you all covered all of that. Did you have something?
I just had a question generally. Are there, when you use AI in the legal world, and I'll steer clear, I don't want to learn about it right now, but I guess I will one day, but are there costs to use this, are there costs to create a document, or are there licensing fees to work, to use a program? And have we talked about kind of how those costs, are you going to ship those costs to the client, or are you going to have a cost for your firm?
That is the last opinion or inquiry and opinion that kind of talks about, tries to draw a line between, if you are working with a specific client and you are using an AI program, process, whatever it is, but you basically are paying for access to that particular program for that particular client. Similar to, we need to, we need to order transcription service for whatever it is for this particular client. That's going to be an expense of the litigation. And draws that line between that set of circumstances versus the broader, I'm using generally an AI drafting tool for everything I do these days. Case management tools, whatever it might be. And to say that, in those situations, that, that broad use of it, I use just in my provision of legal services, no matter what I'm doing, organizing my office, that's not something to pass on to the client. Just like it's almost like a utility to that extent. But tries to kind of set out there that, yeah, there are instances where there may be a particular cost for a particular program that's associated and only incurred because of a particular client. And in that situation, that would be an expense that you could pass on to the client. Of course, with the client's understanding, full free disclosure to the client in the fee agreement, or what have you, so they're aware that that is an expense that they would be responsible for.
Thank you for that. Anybody else? Yes.
This is more just for informational purposes, but I had to renegotiate my Westlaw contract for the firm this year, and I learned that they've gone beyond just the research tools that we're used to. Now you can use their program to check your sites, and so that's additional AI. But they have a whole AI component that they're building. I don't think it's completed yet, but I think it's going to be similar to what ChatGPT provides. And so even what we have now, we think of Lexis and Westlaw as just a research tool. You can add this additional AI component. I opted not to, but it's out there and they're already marketing it. So that can make your bill even more confusing. I don't know if, I want to say that bill was, you could pay a monthly fee and get it. So I don't know if you can break it down by client, or if you can add in just specifically for that client, do an add-on.
I think that's a great example of how these issues will evolve. I mean, even while we were studying, ChatGPT introduced, I think it's called ChatGPT Enterprise. I'm looking at Elizabeth Johnson, our privacy and information security law school. But it's basically like it felt like a ChatGPT response to the concern that you'll be putting in information that's going to be in this public resource and trained upon all that. Now they're trying to put little barriers up to say, no, it is secure if, under these certain circumstances and all that. It will continue to evolve. And I think just like you're talking about, Lori, the question about how can I break down this use of Westlaw's AI for this particular client, that's going to be, and to Sydney's point too, these things will be issues that are presented to the ethics staff. But then I guess even thinking back to what you observed, Wade, and what the intention of this opinion is, and what Warren said earlier, it's a foundation for future opinions. It's grounded in principles that have existed and will continue to exist. They're still applicable. It's really the individual lawyer's responsibility to figure this out, to talk with their client. You know, if they're going to bill them for something, you need consent with the client to make sure that they're aware of what's going on, you know, and what isn't clearly excessive and so forth are going to be issues we will tackle as this topic just evolves. And at some point, I'm just going to give up and ask Suzanne to take it all. I'm kidding.
Yeah, I'm the oldest one up here.
I just have one other thing to add. The opinion 2 really, I think, sets out considerations when you're going to use AI, of things you as the lawyer need to think about the security and the reputation, and I think that's really good guidance before anybody uses it. So that was a good job.
Just a question, and it might relate, Brian, to where you were going with the description you gave of how they're parsing the services. We have clients who are working really hard to distinguish machine learning from artificial intelligence. So that the artificial intelligence is the creepy creation of data that spooks people, and the machine learning is there's nothing to see here, so it's fine. On purpose, because that's where the laws are going. They're going for the artificial. So with that in mind, I wondered if you all intentionally stayed away from the phrase machine learning or not, and whether how that factored into your thinking.
Yeah, so we try to kind of set out in the background that artificial intelligence as used in this opinion kind of encompasses everything. And there's a sentence there that says that it encompasses but is not limited to extractive and generative AI, natural language processing, these large language models and machine learning and all that kind of stuff. So it's addressing that's why we kind of at first said like, well, we'll take a 30,000 foot view and realize we're really taking like a 75,000 foot view of this and just saying this, whatever you're encountering, machine learning, generative AI, all of that stuff, it's really grounded in the principle of competency, confidentiality, supervision. So that's why we wanted to take it broad. I think dissecting into the different types of processes that are developed is going to be something that might be for later opinions as those things will, but right now we were just trying to keep it really broad. So we do reference machine learning in like kind of a very quick thing, but we refer generally throughout the opinion to AI, no matter what it is. And that was kind of the intention. I don't know if that would be confusing or I don't think we're also hoping not to make it terrible, like overbroad. We're going to make it broad intentionally because no matter what you're using, you need to use it competently and maintain confidentiality, etc. But yeah, that was the intent of the opinion. That's kind of the parameters that we set.
I like that. I agree with the way you use it. Organic is good in this space.
Yeah.
But it got me to thinking, reading it, the machine learning aspect, so they would call it extractive.
Yeah.
That's been around a while.
Yes.
And companies like Lexis are not trying to point it out to you.
Right.
So it's harder for the lawyer deploying the opinion to take and use your advice, but they still have the duty to do it. But if they're being thoughtful, they have to get there with what you've written.
Yeah.
Thank you. Sir?
Think about this, as far as billing, when I was still in private practice for Westlaw, a lot of that was passed through to the client. The way we had just started learning about how to use Westlaw. We were still book learning, so we had to get it. And nowadays, now I get the bills, and I don't think I've seen a bill from a law firm doing our research that had Westlaw anywhere on it, right? And it's like that's just part of what you do when you hire a law firm. It's part of their overhead. So there's going to be an evolution here on that front. And whenever you're ready, I've got a motion.
I think we're ready. Yes, sir.
Move that we approve this for the executive council to send to the full council for approval for publication.
Do I have a second?
Second.
All right, we have a motion and second to publish for comment. Any discussion? All right, all those in favor, please say aye. Aye. Any opposed, say nay. All right, passes. Thank you all. Next, we have reconsideration of prior inquiries, starting with the installation of third-party self-service kiosks in the lawyer's office and inclusion of lawyer and third-party advertising efforts. So that was a lot.
You all probably remember this opinion. It was actually published for comment after the October meeting. But this is the opinion that is about a lawyer allowing a third-party business to install a kiosk, which is a laptop, or a tablet, into the lawyer's office for alcohol monitoring ignition lock services that the lawyer would then offer to his or her clients. The lawyer will receive a referral fee as well as a rental fee, and they will be also included in the company's business advertisement. The proposed opinion concludes that collecting a rental and referral fees gives the lawyer a financial interest and therefore is a personal conflict of interest. However, the conflict is consentable provided that the lawyer makes a full disclosure to the client and obtains the client's informed consent confirmed in writing if the lawyer is going to recommend the use of the kiosk to the client. The proposed opinion also permits the lawyer to participate in the business's advertisement, provided that they follow Rule 7.4 on intermediary organization. As I said, the opinion was published for comment after the October 2023 meeting. We received one comment, and actually from the lawyer who sent in the inquiry, Mr. Reese. He is not happy with the opinion. He wants us to take a look at another opinion that was previously written by the State Bar 99 MPO1, which provides that a lawyer may not accept a referral fee for referring a client to an investment advisor. So I think we need to take a look at that to determine whether or not we've got it right in our opinion. And so my recommendation is that we return it back to subcommittee for further study based on the comment.
Nicole? Subcommittee members, Kevin. Yes.
For newer members, I think this is a good example with the subcommittee, and even when we talked about it in full committee, with ethics opinions, we're basically detailing what is allowed or not under the rules, whether we think it's really a wise idea or not. This is one that I don't think any of us were terribly pleased with being able to say, excuse me, you can do this under the rules. But that's where we came from with the analysis of the rules and the prior opinions. As chair, and I know we briefly mentioned this earlier, it's one with the comment and the request to review a different rule. I would happily move this back to subcommittee so that we can do more thorough discussion and take that into consideration. Definitely on this opinion, more so than any others.
I second it.
Oh, wow, okay. We have a motion and a second. Any discussion? All right. All those in favor to send this inquiry back to subcommittee, please say aye. Aye. Any opposed? All right, that goes back to subcommittee. All right, we are going to take a little short break. We do have 2 more matters to take up the new inquiries. All right, so about 5 to 10 minutes.
Looking a little different than the last time I saw I spent the first day out and I'm gonna go. Hi.
little break, and so we're gonna move into new inquiries, starting with the use of the notes function in Odyssey eCourt system.
All right, and Nicole's handling this one, but I want to provide you a little bit of background on this inquiry. We had received, when eCourts was kind of unveiled and implemented in the first pilot counties, then we did receive a couple of calls on this particular issue that Nicole will explain a lot more, and the opinion goes into. We kind of wanted to hold off on issuing any opinion because it's a brand new system. You know, there are things that need to get worked out and so forth. And also wanted to get more information on it. Over the past couple of months, I know at one point, particularly in the fall, and I was contacted by Judicial Standards because judges had been calling Judicial Standards saying, you know, we see this notes function, see some information in there. Are we supposed to be looking at this? Are we allowed to look at it? Should I talk to the attorneys? Is that an ex parte communication? Things of that nature. And so, so I spoke with Judicial Standards, and the executive director of Judicial Standards, myself, went over to AOC to talk with the executive director of AOC and the folks that are kind of heading up their eCourts development and so forth, and just kind of said, you know, these are the complaints that we're receiving in both of our agencies, and you know, we think that there's an opportunity for some guidance, and they were receptive to the idea of some guidance being out there that particularly they could provide to new counties as we go online throughout the state. So I want you all to know that this is something that's been kind of talked about by both the State Bar, the Judicial Standards Commission, and AOC, and we're trying to work together to make sure that the appropriate guidance is given to lawyers and judges that are eventually all lawyers and judges that will be using the eCourt system. So with that background, Nicole is going to take us through the opinion.
So a little bit more on background.
Yes.
The eCourts system is called Odyssey, as many of you know. The DAs and the ADAs can add comments to particular sections of a criminal case's online file, which is called notes. So these notes section is intended to assist the DA's office in carrying out its statutory obligation to set the calendar for district court and superior court. And any text entered in the notes section is viewable by the clerks, by the judges, and any member of the public defender's office. So we're talking about who can view it. The private counsels, lawyers who do criminal defense out in private practice, they can't review the notes from their own computers. They can't log in with their own personal login information into eCourt system and see the notes. Instead, private lawyers have to go to the courthouse and use a courthouse computer in order to review the notes in the Odyssey system, in the note system of a criminal defendant's online file. Neither private counsel nor public defenders can add any notes, so only the DA's office can add notes. In inquiry number 1, the facts are that the defendant is charged with assault. Prior to retaining his lawyer, defendant is called and failed twice. Prior to the hearing, the defendant's lawyer informs the ADA prosecuting the case that he intends to request a continuance. The ADA then subsequently enters into the notes section of the defendant's online case file that the defendant has a motion to continue. The ADA does not tell the defense lawyer that she has entered these notes, and the lawyer is unaware of the note. At calendar call, the presiding judge reviews the note and denies the motion to continue, citing that the defendant had previously been called and failed twice. So the question is, do the rules of professional conduct permit the ADA to enter the text in the notes section of the defendant's online case file as described above in the scenario? The answer is yes, because the ADA is statutorily required by 7A-61 to prepare the trial dockets for criminal cases heard in superior and district courts. So the opinion goes on to say that this is not an improper ex parte communication by entering the notes. Inquiry number 2, It's the same set of facts, except that in addition to the ADA adding defendant's motion to continue in the notes section, the ADA also adds the defendant has been called and failed twice. Again, the lawyer is not notified that the notes were entered and is unaware of the notes. The presiding judge sees the note at calendar call, denies the motion to continue, citing that the defendant has been called and failed twice before, and sets the matter for hearing later in the week. So again, the question is, do the rules allow for the ADA to enter the notes in that fashion as described in the facts? And the answer to this one is no. So this second opinion is just talking about the additional note of the ADA adding that the defendant had been called and failed, whereas the first opinion is just about adding that there was a motion to continue. So adding the defendant has been called and failed twice is an unsolicited substantive remark about the underlying case and is prejudicial to the administration of justice in violation of Rule 8.4D. The proposed opinion cites 2019 FEO 4, which cites Rule 3.5, that's the ex parte rule, comment number 8, that states that allowing one party unfettered access to make off-the-record arguments to the presiding judge via the electronic communication undermines the principle of fairness and equal access to the presiding judge. The opinion further goes on to say that the ADA's additional note that the defendant had been called and failed twice, although it is true, is unsolicited by the court and is unnecessary to understand the procedural reason for the case appearance on the court's calendar. This language addresses the merits of the lawyer's motion and is therefore more appropriately reserved for argument by the ADA in open court, where the defense lawyer will have the opportunity to respond. At no time does the ADA inform the lawyer of the note, and the lawyer has no reasonable prompt access to the language because, as I stated before, the lawyer has to go to the courthouse in order to review the notes. And there is an added burden placed on the private lawyers who have to go to the courthouse in order to review the notes, and they also have to think about, is there a note? I was just talking to Judge Julie Bell earlier, and she indicated that a lot of lawyers don't know about this notes section, so they don't even know to go look for the note. The proposed opinion concludes that an additional note is prohibited as an ex parte communication with the courts in violation of Rule 3.5 and is prejudicial to the administration of justice in violation of Rule 8.4D. My recommendation is that we assign this to a subcommittee because we need to talk about this, and that we invite a judge, at least one judge, members of the DA's office, members of the public defender's office, as well as lawyers in private practice who handle criminal defense.
All right, thank you for that. And we have identified some subcommittee members already. First being Judge Julie Bell, if you want to give your initial thoughts.
Yes, I'm certainly, of course, aware of the note feature. I spend 3 weeks out of 4 in family court, so mostly I use the note feature to talk to my case coordinator about whatever she's sending me back and forth. And I'm aware that that the lawyers in our cases generally cannot see that. But I do go 1 week out of the month, sometimes across the street, and I get notes. But the type of notes I was getting, I put notes in. For example, if there's an argument about a motion to continue. And before we would put that on the back of the shuck. Those who shuck, you might write state's continuance, defense continuance. I will make a note. Parties appeared in court, so-and-so wanted it continued, other side objected, granted the continuance, told them to be ready next time. Same. Because I look for those notes when I'm in court to see what happened before, because that's effectively our shuck now. I was not thinking about it in the sense of, until I read the preparation for this meeting, about the sense of the DA having something to say. The DAs do generally task us. Let's say I'm in a DWI court, I'm going to take a guilty plea to a DWI. The DA will send a task, and so when I pull it up in my computer, and they might put pleading, asking to continue the case till for sentencing. And so in my mind, initially, it's like this is just a general info, but as I looked at this and thought, no, the other side really can't, it really raised an issue for me that I had not really hadn't been on my radar screen. But there's definitely access to that. Now, I still think it's totally appropriate for judges to give each other notes so that we know what's happening, but I was not considering it from the DA's perspective, and I think it's a huge issue. So I definitely support referring it to subcommittee, and I will receive the
lesson.
Yes.
So, all right, thank you. Yes.
I
Go on
volunteered
inside
on the
next.
committee.
Yes.
I had experienced something involving this very, very recently in Mecklenburg County, where we made an appearance in our courtroom 1130. It's our administrative court, it's our clearinghouse. And we were there. We appeared. In fact, we have to be there before 11 o'clock because they shut down the courtroom beforehand. The clerk's office in the notes entered an FTA, fair to appear and apply. And on this later entry in the day, the DA's office entered the new court date that we had obtained. Now, one, I had a very ticked off client saying, I paid y'all good money and you no-showed and now there's a call that failed. And in Mecklenburg County, we can get it added back on. I made an inquiry to the district attorney's office and said, why are we doing double note entries on this? And they said, well, the clerk's office is entering them sooner than we can actually get them entered in. So my primary problem right off the bat is they're relying on notes that were factually, substantively, procedurally wrong, okay? And then you've got, let's say this client picks up a domestic violence case, and there's gonna be the 48-hour hold, and there's the notes, and lo and behold, oh, well, they missed a speeding ticket before failure to appear, which was wrong. And unless you scroll down and saw that we had a new hearing date assigned, and it was actually assigned the exact same day as the FTA went out, you would think, well, Powers no-show. So I have a real problem with these notes, ex parte or otherwise. And I'm a tech person, and there's been some good and some bad. But the consistency, or maybe the lack of consistency on the materials that are being in Odyssey is very, very problematic. And judges could be looking at going, well, FTA, and I want them to come back, and I want to pull a rabbit on me, and it's wrong. And unless you know how to look, there have been entries, and we've seen this time and time again, not just with me, but other professionals in Charlotte. It's not a perfect system, it's not an imperfect system, it's a terrible system, but there are problems with it. So I'd volunteer for the committee if you're looking for somebody or not. I have a vested opinion.
You're already there. You as well.
I'm gonna volunteer Eddie Thomas for this subcommittee. Eddie is the supervisor of the Violent Crimes Unit at the Public Defender's Office in Charlotte, and enjoys a magnificent reputation amongst his peers down there. So I'm going to toss this to Eddie to talk about, and then I'll just say a few words at the end about what my opinion is.
All right.
Yeah, Mr. Thomas.
Thank you. I'm putting him on the spot like that. No, I think this is a very important issue. I'm glad to see the committee taking this out. I think Odyssey is new. I mean, it's new for everyone, and everyone is trying to figure their way out, figure their way around the system. You know, in Mecklenburg County, we've been taught that, you know, just because we have this new system, it shouldn't take the place of the way that we did things before. And so communication is key. But in that, you want to make sure that you're following the rules of professional conduct. Ms. McLaughlin, I think you said public defenders could not send notes. We do send notes often. I send notes on cases, particularly, you know, mainly my notes are when it comes to an agreement between me and the state. I will let the judge know that the state has agreed to this and is okay with me handling this ex parte for any motion or to withdraw anything I file. But, you know, I want to make sure that everyone's following the rules. In reading the proposed opinion, I certainly see the difference between the first and the second incident. But I know as someone who practices in front of judges, it's very important. Whatever is said to a judge, whatever is put in front of a judge, you want to have as much control over that as possible, so that you are representing your client in the best way possible. So I understand the difference between what happened in the first incident versus the second incident, and I do agree that that additional language is something that should have been argued in front of the judge instead of instead of being added in the note section. But I am certainly happy to be a part of this, even though sort of told, but I'm certainly happy to be a part of that committee. I'll look forward to it.
Thank you. Yes, sir.
And I'll be short here, but this notes thing gives me a lot of heartburn. Not as much heartburn as we're going to get into with our kiosk subcommittee back there. That never did go past my throat. So Nicole, here we go again. As I said last time, you know, Fran got me to yes, but just barely. But I think that, you know, that opinion was technically right, sort of like our 1.6 was technically right, but there's just something just wrong about it. And there's just something that sticks in my throat about these notes, and because it is there are no guardrails on it, and they're no, you know, the DA can put most anything, and the restriction of private lawyers not being able to come have access to it. And the actually majority of practitioners don't even know this notice thing exists, which is a real problem too. So I think the subcommittee can work around this, and I'll be glad to be on it. But you know, Eddie can ably handle it for Mecklenburg County. Bill too.
And so I just had a question. Obviously, it's a big issue that needs to be addressed, but I didn't know if big picture, is this something that AOC can fix with the software? I remember when the Chief Justice talked about, you know, that this company we hired has done other states, and so maybe it's been explored and fixed. That was
a part of the conversation that we had with AOC. Just even a question of this note section, you know, it's built in. I think it was built with the best of intentions to be used a particular way, but it, like I think Evan just said, there's no parameters on it. And so we're trying to figure out how to use it. We had asked if there is a way to put permissions on it, you know, like within a particular system, maybe only certain people can see and use something of this nature, like it's restricted only to judges and clerks or whatever it might be. And they're looking into that, but I think just from our own experience with recent database development, sometimes when we have a feature like this in just the general case file, then that might be too specific of a restriction to put on. But they're looking into it, and also just understanding the issue that's there and what other potential alternatives there might be that are, I guess, reasonably deployed and implemented. So that is a part of the conversation, and I think AOC needs to be, a representative of AOC would certainly be invited to participate in this subcommittee, because again, the whole goal is just to get everybody on the same page about what are our ethical responsibilities, but just recognizing we're using this system, and we need to figure out a way to all kind of collectively move forward together. But that is a part of the inquiry. Maybe not our inquiry, but it's been submitted to AOC.
So before I come to you, Judge Bill, when you were speaking about the judges having notes, is there a section where just judges are able to see the notes?
Not in my understanding is the notes go onto the file, so whoever has. Okay, so I mean, I'm mindful. I don't put anything like "hated this lawyer" or something in there. I don't put that kind of information in the notes. But I think anybody who has access to that, the note section. So no, I'm not aware that it can be restricted. But the other piece I thought about, and I just thought about that sitting in this meeting, because I'm so rarely in criminal court, I'll be back in family court and I might get a motion to strike a called and failed. And so I'm reading the motion. Okay, my client was mistaken or something came up and they didn't appear. And those go to the DA's office first, and then they come to the judge. And then the DA might write in, no, they showed up at this. And so I'm looking to see what the competing interests are. And then I'm making a decision after I get all of that information. Am I going to strike the called and failed? Am I not going to strike the called and failed? So it is a huge issue.
I was just going to say, just practically speaking, if I'm looking at a screen and I see a note from a district attorney, I'm never going to act on that without going on the record and saying, hey, you know, this is in here, Mr. DA, did you say this? Mr. Defense Attorney, what do you think, is this correct? You're not going to, I would never do that. And I think that it's incumbent on judges not to, even if you see that, there are steps you need to take. But in a lot of ways, it's no different than going through a court file and seeing if there are 2 FTAs in there. That's part of the file, and judges do that all the time to determine if they're going to continue a case or if there's a problem. So I don't think it's as black and white, because I think the bench has a lot of obligations to make sure that there's not an ongoing problem there. So that's my 2 cents worth.
Did you have something?
Yeah, I think to see if Odyssey can generate an email automatically when one of these notes goes in that will alert these private lawyers, that's at a minimum. Also, you don't want this note section. I'm not familiar with it because we haven't rolled out Odyssey in my district, but it's not a place where we're having arguments back and forth that should be heard in court. I can see email sometimes becomes that for us on the bench, and it doesn't need to be a playing field for these competing arguments. And lastly,
This is on the record.
yeah, it's off the record. Like to see anybody who serves on this committee. I have somebody from the rural district. I think we have Raleigh and Charlotte represented, but also a place where Odyssey had already been rolled out, because I'm not competent to talk about. I don't even know what that looks like.
Yeah.
Absolutely.
Well, to that point, I know, I was just talking with Tom Anglem, who's the DO from Washington, and he said they're going live, I think, next month. And he had mentioned that there's already some talking about this, and talking and instruction of just be mindful of what you're putting in and who can see it, to kind of, like, to your point, Judge, of just, there's some responsibility on the attorney's part, just like it's beyond the judge's part. And I know that was some of the things that you articulated, Judge Foster, that judicial standards had relayed to me, that some judges are seeing this and wondering, one, I feel like I shouldn't look at this, even though I can maybe go in the file and discover it myself, but just seeing this statement from one of the parties that's kind of exclusive to that party, and the other side, the private counsel doesn't even see it, doesn't feel appropriate. But then the question of, do I need to correct the attorneys, and all that, and that's where we were kind of thinking that an opinion could be helpful to everyone to kind of bring the issue up to the forefront of our minds. And it very well may be a thing, especially with the system. When I understand the permissions and restrictions really are based upon email addresses. And so that's why if you have an NC Courts email address, then you're kind of in the group of people that can see Odyssey in a different way as opposed to private counsel. And so, there's a lot of different kind of factors here and some technological issues that we're just going to run up against. And it might just be that, the system cannot be changed necessarily, but lawyers need to be aware of their ethical responsibilities and the potential for running afoul of the rules in using the system in a particular way. That's going to be the discussion, I think.
Yes.
I just think we, for the drafter of this opinion, whoever it is, I think we need to be careful about our use of ex parte. Because one of the issues we had when we had such a hard time getting 2019, whichever that one was, one was some loose language from some prior ones about ex parte, because if, in fact, PDs can see it, it may not be ex parte. In terms of the kind of broad language we use, we need to be careful that we tailor it to the application. I think what everybody's purpose is to make sure people have equal access. I think we need to be careful with language, because then that gets picked up and used in other opinions, and we just need to be cautious about how we write that. I'm sure you will be.
Yeah, well, and that's I think that's where we're trying to, Nicole and I worked on this one together, and trying to parse out that, with regards to public defenders, it might not necessarily be ex parte because they see it. But private counsel, it would be ex parte. Even though it's the exact same statement, but even in addition, even if it's not ex parte, for a public defender, it's still prejudicial administration of justice per that 2019 opinion, because it's unsolicited substantive comment that is just offered, and there's clearly no notice of it, but even if you get notice of it, it's still not an appropriate comment even if it's kind of displayed because of the unsolicited nature. So yeah, we're parsing that.
I think that's the vein I can see in that it's unsolicited, unnecessary commentary that shows the ex parte, just so that it doesn't believe that ex parte doesn't bleed over into. I think we pretty well nailed that when that door shut for a while. To make sure we don't use that as that loose language doesn't get us back in trouble, because it's a valid reason to do it on the other side, unsolicited, unwarranted, and also it could be it is prejudicial. And so I think that's the time that we try to craft the opinion that way and stay away more from the ex parte nation, because they can fix the ex parte and it still might be prejudicial.
That's right.
So I think that's the prohibition is that way.
Anybody else want to comment? Yes.
I just have a question. I just want to confirm, this is only applicable or limited to criminal, right? Because in Odyssey, in civil cases, no attorneys have access to the notes section in their Odyssey. Is that right?
My understanding is yes. I don't know if there are other scenarios where this might come up. I guess I'm thinking of other, this is the whole question. Right now, it's all based upon whether you have an NC Courts address. So if you have an NC Courts email address and you are a civil litigant, I don't know if folks with the attorney advocate, guardian ad litem like child welfare, if they have NC Courts access and they might put something in the notes. I mean, there's the possibility. I'm not sure exactly the extent of it, but I think it is primarily focused on criminal, and it comes up more so in criminal cases because the ADA is setting the calendar, setting the docket, and sometimes they put just a straightforward, this is what it's on for, or sometimes they add a bit of background, maybe even editorial comment about the reason for its appearance. But yeah, so I agree. I think right now we're looking at criminal cases. There may be application in others as the system grows.
Sorry to throw a further wrench, but you may want to look into 50B protective orders because they're not being entered in the system. So even if I know one's been entered, I have no way to look at that at private counsel, whether I've filed it or not. So it is it's outside the notes portion, it's tweeting.
Okay. Does the public defender's office have access to 50B?
I don't know.
They should.
I'm just not seeing 50Bs. That may be unique to our jurisdiction, and that could be something that's changed.
Well, that's already been online in its own system.
What 50Bs?
Yes.
A separate system.
Yeah, it's already a separate DV filing system that's been in place already. But I'm not sure about that part of that. Anybody else? So I have a motion.
Can we send it to subcommittee?
All right, second, I have a motion and a proper second to send this to subcommittee. Any more discussion? All right, all those in favor, please say aye. Aye. Any opposed, say nay. All right. Thank you, everybody, and thank you for those who have agreed to serve on the subcommittee. If you would like to serve. All right, inquiry of, is it Lipford?
Lipford, yes.
Duties for inherited confidential client information. We have Susan.
Brian and I both worked on this one. So an interesting background, I guess in the 1930s there was a murder of a pretty famous person in North Carolina, and his spouse, it was his second spouse, and she was also described to me as a Broadway torch singer. So the spouse and then a friend were charged with the murder of this public figure. A lawyer was, lawyer A, defended the friend, and ultimately the charges were dismissed. The lawyer who defended the friend went on to stop practicing the private practice law, went on to be an in-house counsel, subsequently died. The file pertaining to this love triangle went to his wife, and she held on to it until she died, and then she gave the file to Lawyer B. And Lawyer B is actually the second cousin of the friend who was originally charged.
And Lawyer A's son.
And Lawyer A's son. So this case has been something that was in the news back in the 30s and evidently is still a topic of gossip and conversation. In fact, a nonprofit organization recently put on display about the case, about the allegations and the trial or coroner's inquest. And lawyer B, who happens to have the file, went to the exhibit, and he was walking around and he said, I don't think that's exactly what happened because I've got the file. And so lawyer B wants to hand over the file to this nonprofit organization. And the question is whether lawyer B can hand over that file. What obligations does lawyer B have as far as this file? This is not a former client of his, it's not a client of his law firm, it's just a client's file that he took possession of. And he is a lawyer. So we drafted two different opinions. Well, it's not going to be an opinion, it's probably going to be an EA, because this is an example of something that is not an issue that pertains to a lot of people. It's a very specific issue this individual is asking. But we drafted two possible answers, but the only real difference is one says that lawyer B can turn over everything that's in the public record, and that kind of relies on the exceptions from Rule 1.9C, and the other one says you can't turn over anything. But the real issue that we have to look at is, does this lawyer who got possession of this file have any fiduciary duty? Do any of the rules of professional obligation apply to him? And if they do, then I think the answer is, I think he can turn it in public, but not in private. But the real question and what we want you guys to think about is whether by taking possession of that file from somebody who wasn't a lawyer, do the rules of professional conduct attach then such that lawyer B is required to protect the information in that file, or is it fine for him to just turn it over?
Staff is essentially split on this thing. So
Well,
we're
not on the main point.
Yeah, not on the main point, but it's not split as in, we're just like entrenched in our camps, but we were going just back and forth all around the table on this thing. So we invite you to be on the ethics staff and help us figure this one out, because I think it really does, like Suzanne was saying, it's kind of getting down to this idea of a lawyer who inherits, comes across, takes possession of a client file that did not belong to the lawyer, it wasn't the lawyer's client. What duty, if any, attaches? And of course, there's the kind of the pendulum swing is at the extreme that lawyer comes across a client file, wasn't his client's. Can they just say, well, it wasn't mine, and there's some interesting stuff in here, I think people should see it? Or is there some duty of confidentiality? What should they do with that opinion? Is there some exception of, depending upon what's in the file, all those different things? So what do y'all think?
Yeah, I don't think lawyer B has a duty to that client unless, is it, him and his father in the same law firm? No.
Nope.
Okay.
Never practiced.
So it was inherited sort of, it's just paper, really.
Mm-hmm.
It was boxed up and actually the chain's already been broken because the widow had it.
Right.
As he's going through papers, I don't see any attorney-client relation produced.
The widow got it, and she turned it over to lawyer B. He didn't just happen upon
He
it.
didn't just find
She
it.
gave it to him,
Yeah.
but I'm not saying that that's.
Yeah.
I don't think that would change my analysis. I don't think there's any duty from that one.
I'm just curious where is the argument that there is a duty? Because I feel like I must be missing something.
So I will confess, I'm of the opinion that there's some sort of fiduciary duty, because I think about kind of the message that it sends to the public, that if your lawyer takes in confidential information and then keeps it in their client file and passes away with the client file still in existence 40 years later, whatever it is, and some other lawyer finds it, then some other lawyer could essentially just say, well, it's not my client, let's go send it to WRAL. Clearly that's an extreme, but it's the notion that, I guess I looked at one of our older opinions that basically kind of talks about a lawyer that gets a client file or somehow has to be responsible for a client file. Maybe it's a partner, maybe there is a relationship in a firm, But there's just this notion of some sort of, I guess that the lawyer has now taken possession of a file that was not belonging to his client or associated with any client, that there's still a fiduciary duty to at least safeguard the information and dispose of the information. And in that situation, just destroy the file. I guess it kind of sat in my stomach that lawyer B should never come into possession of this file in the first place because it's not his client.
Mama gave it to him.
Mama gave it to him, that's right. Mama shouldn't have had it either. But she did, yeah. And then, she gave it to lawyer B, why? Is it just because that's her son, or was it because lawyer B is a lawyer, so he'll know what to do with it? Is there some expectation that lawyer B should have a responsibility to say, like, this is confidential information, juicy though it is, I can't do anything with this because clients are entitled to the principle and the expectation that the information I provided to my lawyer, and in this case, on murder charges, is going to remain confidential? Or does lawyer B just, are they free and clear to say, wasn't my client, I have it now, so I can share it however I want? And that's one of the things we did clarify with the inquiring lawyer, that the desire, there's public information in this file, and I think he said that public information is in the possession of the nonprofit, or certainly available elsewhere. His intent is to share his father's notes that he took, and the efforts that were made after the case and charges were dismissed, and kind of to assist the client. So that's the intent is really to share what we're talking about, like work product, and those sorts of notes that the attorney took on the case in the course of the representation.
And we do have ethics opinions, old ethics opinions that talk about an attorney's duty when they get a deceased lawyer's files. But that is more of a direct A, B, not A.
To assume those duties.
Because you keep calling this person the client. Mm-hmm. This person is not the client.
Right.
There is no client. I mean, that's.
It's not lawyer B's client. It's a client. It is someone else's client.
Right.
And
but that's my whole point.
Yes.
It's like, as far as this lawyer is concerned, I get where you're saying, well, maybe we should keep it, but I mean, should we be writing hanging out?
You can write a rule for perpetuities for confidentiality.
That's my 2 weeks.
Is this Libby Holman?
What's that?
Libby Holman.
We redacted information.
I book about it.
And we're being recorded.
Yeah, live stream.
But I mean, people know about it.
Yeah.
Right.
Well, then, probably shared information with the first attorney under the assumption that would remain confidential. I have no idea what the notes say, but they could be scurrilous. And I don't know if there's an opportunity for somebody to review those other than the 85-year-old lawyer that's currently got custody of it. But to me, I think it would be a chilling thing if something that was shared in confidence 90+ years ago through a crazy set of circumstances saw the light of day. I just don't think that's something that we should sanction. And I would not be in favor of saying, yes, turn this over and be part of the public record, because really, according to the attorney who's currently got custody of the file, there were quite a few incidental errors which he saw. And I think he can kind of share whatever he knows about that, independent of what's in the notes. But I'd be very, very careful about precedential impact it would have to share something that was giving confidence to the attorney, thinking that that attorney was going to retain that information in confidence.
Yes, David.
First of all, I make a motion that we send this thing to subcommittee.
I literally just whispered that.
But I think it is different. Let's say that parents thought that Evan were to pass away. And
hey, I grew up in Winston-Salem, and I know all.
Everybody knows what case this is. Yes. And if I bought Evan's house, let's say, and there ended up being stuff in the house that he had put there, and I just happened to be a lawyer. I bought Evan's house because I like Evan's house, and there's files in there. I think the duty on me is different than if it was the law firm. We all know what that answer is. If the guy, lawyer A, the dad should have sent the file, should have never left the law firm. When he left practice, he should have left the file. We all know that's what should have happened. It is different because of the factual circumstances. I think we need to plumb around that a little bit. Fascinating inquiry. I think one that's, I can see why staff is divided on this.
And I agree with Craig. I think the fact that it passed through the wife first doesn't matter. The fact is that the lawyer died, and I don't know that sort of the file kind of stayed in limbo in the estate for a while, and then the mother passed it on to the son, who was a lawyer. And this is assuming, once again, with the expectation that that lawyer would bring whatever proper rules of professional conduct to bear on the file. And I know 1.9, we spent 2 years knocking around 1.9, and I think that may apply, but I still think
That would only apply to the couple.
The higher duty of a lawyer who comes in possession of a file, no matter from what source, from another lawyer, all of a sudden the rules of professional conduct fall on the lawyer in possession of the file.
That's what I was going to ask David. If you bought his house and you found client files, would you just give them to anybody that wanted them?
I'd sell them to somebody.
Might
be a screenplay in this.
Something Netflix or something.
I get ChatGPT to write me a novel. I know what I'd do. I'd call y'all up and I'd either talk to Brian or Nicole or you to find out the answer I wanted. I knew that. Since there's a division up here.
So we have lots of hands. Wade, I know you will.
I don't know if I've got a conflict of interest or not, but I'm interested in history. And I don't know whether this, I think the attorney who sent the inquiry is a wise and ambitious person and a very ethical person. But I don't know whether his mom got the file because she was a lawyer's wife or because her husband happened to be the cousin of the guy that was involved. And this may have been something that was more akin to family history than legal materials that were intended to be protected by the rules of professional conduct. And I think, from my perspective, I'm more interested in why he ended up with the file and what those circumstances were. Because if what this is essentially is family history, you gave him an out by saying he could get consent. But what would that look like? There are probably by this time 60 or 70 potential heirs to the defendant. So I think we all struggle with the idea of the sacrosanct nature of attorney-client competencies. And if we start with the premise that there's an attorney-client relationship that's passed along, we don't have but one answer. But if you start with the premise that somehow this material was transmutated from the file of a lawyer to the realm of family history, then maybe you come up with a different answer. And also, isn't there a way to simply give this person a verbal answer and not, create hard cases make bad law? Is there a way to do this in a fashion that will not set a dangerous precedent that can be extrapolated into something totally different?
There absolutely is, and that's something that we have talked with, or I guess I should say Suzanne has communicated with this person and tried to offer some different some different opinions or kind of different ways of thinking of it, I guess. I don't want to
But
get
the
into
reason-
specifics, but
The reason that it is an EA is because we can't decide.
yeah. And that's where the EA comes in, because it would be only a communication to the inquiring lawyer. If you all decide not to issue an EA, that is an option as well. You know, it may be kind of a decision of the issue that needs to be communicated, but, you know, I guess not, completely informally. But even so, you know, because of the tear that we had, I believe that, you know, we've communicated, you know, we can't just give kind of a clear, yes, you can do this. And that's when the request came in to put it before the full ethics committee for determination. Because it is a fascinating issue. But yes, we can decide how we want to communicate this inquiry.
I know, Sydney, I saw your hand up, and then I'm coming around.
Yeah, I was just gonna say, the difference, like, so if you were, I do think custody and how you got it is really important, because, you know, family law cases, I give my clients all their documents back besides my work product, right? And then when the time comes up, I destroy files, so that I am not, like, holding on to it, right? That's, I mean, one, destroy the damn file, we wouldn't be talking about this 500 years later. But secondly, I think the other issue is, if my client, if I return the documents to my client, and then somehow later on it gets out to the public use, that was the client's choice. I think that if you were a lawyer in a different situation where you were going and actually at an auction at a storage facility and some attorney who, you know, never got rid of their files, you come along 50 boxes of their files, I think that's a very different situation, in that if I'm an individual who happens to be an attorney who buys a storage unit, I should not be able to, of course, take that information and then subsequently sell it. And so, I mean, it seems like we don't even necessarily agree, but I do think that if it's a situation where they got it because it somehow got back to the client, and however the client decided to distribute that information later on through the file, that means that the attorney doesn't have any other issue. And then I'd also just say, I don't know why the attorney is so hell-bent on trying to provide another narrative to this nonprofit. I mean, I do child welfare law all the time. It's confidential. The news always reports things that are inaccurate. And I have to bite my tongue throughout the entire process and say, I can't talk to you. And then the narrative continues to go into existence, and there's nothing else that I can say. So I mean, maybe I sound callous, but I don't know that I feel like
I think it's because how famous this case is, and there's books written on it, and it's not.
Yeah, I mean, I've had lots of, sadly, you know, child welfare cases that have been in the news that I've never been able to correct, right? And it is hard because I know that the outcome of the case is different in court, but because it's a confidential case, I can never disclose what actually happened and to correct the record. And so I just think that, you know, in this case, I don't know that if there's a way for him to just orally fix something without providing the file, I said I'd support that, but I don't know that. I'm not passionate about making that rule for him.
Does it matter what happened when the attorney B came into the file? Did he keep it for a long period of time? Did he safeguard it in his office? Then maybe that duty is an attorney.
He's had it for a while, I believe. Right?
But if it's sitting, if it's going from one item to another, I still don't know if that.
He's had it for years.
I got you. Nancy, then we'll come over here.
I don't know what the answer to this is, but to take off on what Brian was saying, is there some, as an attorney, as a member of a learned profession, I was kind of scrolling through the preamble, right? You know, are there heightened duties outside of this is not my client, right, that come into play here? You know, we're supposed to be promoting the interests of justice and confidence in the legal system, and those are some of the areas that I would think you might want to look at in terms of however this document or these documents got into the hands of this attorney, the fact that they're in the hands of someone who is an attorney now, is there some sort of outside of an attorney-client relationship, something that's governed by our rules of professional conduct? And to me, I'm thinking, just like quickly looking at the preamble, you know, there's certainly language in there that could give rise to a more heightened duty because of the profession that we're in.
Yes, sir.
Well, I want to echo exactly what Cindy and now Nancy and Wade said. My concern is this. I go and buy a storage unit, exactly like you said. Now it's got a box of 15 or maybe 15,000 different client files in there. I have no relationship with them whatsoever. Are we saying by this inquiry and like you say, answering it, giving an opinion, that now I, as an attorney, I'm an investor, I bought a storage unit, do I now have some sort of obligation to contact all these people? To take that time to say, hey, what do I do now with this? Because I'm an attorney, not because I'm an investor, but just because I have to have a law degree and license. And so that's the worry that I have as well. You know, we need to really think, we're going to issue an opinion on this, or give some new guidance. We need to think that through very, very carefully. Because I really don't want that extra. I'm not buying that storage unit for those files. I really appreciate the pro bono work when I get to choose to pro bono work. But now I really do.
Well, as a hopeful kind of alleviation of any potential stress, there's a statute for landlords that come upon rental units, storage units in particular, that they are required to contact the state bar if they go into a property that, you know, they're taking back possession and they find client files. And we usually get that call and we send folks down to clear out those files so we can then probably appoint a trustee and deal with them accordingly. And by dealing with them accordingly, most of the times it's going to be just straight up destroying the files. But other times, if we actually look at the files and there's wills in there, wills that were drafted 10 years ago, we can't destroy that stuff. We try to contact all the folks. But that's something that the state bar takes on as opposed to the individual lawyer. But I see what you're saying. Just kind of that's the terror of this issue. What obligation does a lawyer assume, and what's the extent of that obligation? Even if there's an obligation of I received this file from Mama and it's Dad's file from 80 years ago, and I have a duty to just destroy it, or can I go public with it? That's all part of the inquiry.
Well, of course, the landlord is very limited just to that.
Yes.
I'm an investor. I'm not a landlord.
But I think if you called the bar would send somebody down to get those files.
If I call, if I want to do that. But what if
If you don't want to call?
I don't want to. But I guess the next question would be, but what is my obligation if I don't? If I now have an ethical violation by not calling?
Yeah.
Can you just give it back to the storage unit?
Yeah.
I think,
When?
yes.
First, it's too late to say, don't ask, just do what you need to do.
That's exactly.
We'll retire,
But the contents of that file, and I've heard that the physical paper that's in that file belongs to the client. And I guess technically to the client's heirs, at least that part which is not strictly the attorney's notes. And while I can't remember the family history, it's possible the nonprofit's an heir, or the heir.
I didn't get that
But
impression.
I think we got to concentrate on the fact that that file belongs to the client. It's, I don't know if it's stolen property, abandoned property, I don't know what it is, but it is property. And I'm not talking about just information, because a lot of the information is public. But the physical stuff that's in that file is property that belongs to the client. And if the museum is an heir, that would kind of solve it.
What if they're not an heir? What if they're not an heir?
I don't know. I'm just saying. That might be a way to say, we don't need to decide for each other.
So Warren.
I've got two things. One, very quick, I get very antsy anytime we put a duty on a lawyer. And this needs to be as narrowly drawn to the facts of this as possible. There are 1,000 different ways that a lawyer might come in possession of somebody else's, of some non-client information that he does or doesn't have any idea whether it's confidential or not. And putting any duty on him to call the bar to anything, I have a really hard time with that.
We got insurance for that one.
I know. I mean, if Whitford had called me, I would have been like, damn, now I gotta hire an attorney to give us some advice. That's what to do. I mean,
You have a conflict being on this committee?
So that's the big thing. And the second thing, I cannot think of the more perfect person to chair the subcommittee than Tom Lambert. I mean, this is like right up his alley. The man loves this stuff. And I'm ready to go to subcommittee.
And we do have a motion on the table.
One of the final points, Madam Chair, and I'll be trying to be quick. The Battle case, just to add an extra layer of angst for all of this, there's some possibility that the friend and the court singer had some relationship, and there was an issue going after the death of the victim here. And so if the notes would have happened to touch on that, there'd be a whole nother layer of ickiness was the word that we talked about earlier, Kevin, of issues that could be spawned. That's probably the wrong word to use, spawned. As a result of this increase. I do think a DA is where you go, but you don't want to. But this looks like, I think this is fascinating. I do think there is the difference in how you come into possession. And I think the pass-through, we're not going to know, to answer Evan's point, whether Mama gave it to the current holder because he was the son or because he was a lawyer. And so we're never going to know those answers. And so I think you have to bleed out that part of it. But I think it's something that we ought to give this fellow some action because, unfortunately, Wayne is right. It'd been nicer if he'd have just done something. And there are notes in here. The notes of the lawyer
Ridgeway
would be different.
Right. So we do have a motion on the table, and I think the first part of business of the subcommittee, if it goes, got a second?
I've already got Patty on one subcommittee, but I think this subcommittee needs a public member. And I want to volunteer Patty for a second.
Kevin is volunteering a lot of people.
You took yourself off a committee.
Not me.
But I think this definitely needs a public member on this subcommittee.
Would you be willing? All right, thank you. Well, one of the first points of business you all need to take up is educating us on what a torch singer is. I have no idea. I feel like it's a fancy word for something we really don't want to say.
Might be a synonym for lounge lizard.
Oh, okay.
One other thing I'd like to mention is that I would hate to read a headline strip club in the journal that said, defendant X's attorney's notes now part of exhibit.
Yeah, right, that's what I was just getting ready to say.
Yeah, it's the headline potential.
Right, it's gonna be in the public with that, how they got those notes. And where is that gonna, that's gonna be harmful
I'll serve.
to the profession, absolutely.
I'll serve on.
Okay, thank you.
Second.
We have a motion. Do we have a second to send it to subcommittee?
Second.
All right. So we have a motion and proper second to send this to subcommittee. Any more discussion? All right. All those in favor, please say aye.
Aye.
Any opposed, say nay. All right, thank you.
I appreciate everybody verifying, validating
Yeah.
the difficulty that we were having with this.
And then the subcommittee will discuss whether it's an EA or
Well,
all of them.
Yeah, we'll present.
We definitely don't want to put anything out.
Yeah, we don't want to,
We just are trying
formal
to
opinion.
arrive at an answer.
We'll probably just tweet out our response.
That's all. All right. So we don't have any ethics advisories. Approval for transmission to council, proposed 2023 formal ethics opinion 4, use of a lawyer's trade name for keyword advertisements in internet searching.
Yeah, and this is what we published over the past quarter. No comment was received, so the normal course would be to send this to the council for adoption.
Can I get a motion on that?
So moved.
Second.
Thank you. We have a motion and a proper second to send this to council for adoption. Any discussion? All right, all those in favor, please say aye. Aye. Any opposed, say nay. All right, that goes for the council for adoption. I think that covers everything.
That's it.
And I think that we don't really need a motion if we go through the entire agenda. But I will take one if somebody wants a motion for adjourn.
So moved.
Second. All right. We will adjourn. Thank you.
See you in April.
I know.